George. Good afternoon, everyone, and welcome to this third instalment of the 5 Essex Court SOFA series. My name's Charlotte Ventham. I'm a barrister at 5 Essex Court. We specialise in police law, public and administrative law, inquests and human rights law. And I'm joined today by 3 of my colleagues, Emma Price.
Hello.
Hi, Emma.
Hi.
Remi Reichhold in his kitchen.
Hello.
And one of our current pupils, Jennifer Wright.
Hi.
And this week we are going to be looking at the Health Protection Coronavirus Restrictions Regulations 2020. And this session is going to build on the first episode of our SOFA series, which was hosted by Barney Branston, where he addressed the Coronavirus Act of 2020 and the now repealed regulations which were made in February. And that first episode, if you want to view it, can be found on the 5 Essex Court YouTube page. And indeed, this episode will also be shortly uploaded there. Last week, 5 Essex Court published a guide on the new regulations, and that can also be downloaded from our website at 5essexcourt.co.uk. That guide deals specifically with the new regulations in England, and that's because different regulations have been adopted for each of the 4 nations, England, Wales, Scotland and Northern Ireland. And although the restrictions are broadly similar, there are some differences. And later this week, we are releasing a second guide on the regulations applicable in Wales. Today, however, we're going to look at the new regulations applicable in England. And we're going to touch on the 3 main categories of restrictions that arise in those regulations. So firstly, the restrictions on business activities. Secondly, the restrictions on freedom of movement. And thirdly, on gatherings of more than 2 people. For each of these categories, Emma and Remi will explain exactly what has been restricted. Jennifer is going to briefly address the differences that exist in the regulations for Wales, Scotland and Northern Ireland. And after that, I will briefly set out the powers of enforcement that exist. There is a chat function that you can use to ask questions as we go along, and we'll answer as many of these as we can. But as I'm sure you'll appreciate, there's a limit to how much can be covered in this session. And there are limits on how much we can say about specific cases in a public forum. But we do hope that this will be helpful in demystifying the new regulations. So I'm going to hand over to Emma now to introduce those regulations for us.
Thanks, Charlotte. The regulations, to give them their full name, the Health Protection Coronavirus Restrictions England Regulations, came into force at 1 p.m. on the 26th of March 2020. You might want to have a copy of the regulations on your screen so that you can follow along. There should be a link in the chat box for those of you who would like to do that.
Emma, I think before going into the detail, there are probably a few general points we can make about the regulations. So firstly, I think taking a step back, in the context of this public health emergency, these are pretty extraordinary regulations. And I think it's fair to say there probably hasn't been anything like this since at least the Second World War.
And because the regulations were made under emergency powers conferred on the Health Secretary under the Public Health Control of Disease Act 1984, they came into force even before being laid before Parliament.
And I think presumably that's because the Health Secretary used the special power or the emergency procedure under, I think it's section 45R of the 1984 Act. So as a result of that, whilst it hasn't been laid before Parliament and it came into effect before it was laid before Parliament, there is a time limit now of 28 days within which the Parliament must approve the regulations.
That's right. And a second general point is that the regulations are limited in time. So under Regulation 12.1, they will expire after 6 months, but there is also a requirement under Regulation 3.2 for the Health Secretary to review the need for the restrictions at least every 21 days.
But I think if we turn to the meat of the regulations, Charlotte's already pointed out that the restrictions broadly fall into 4 categories. So the first category, we have regulations 4 and 5, which deal with restrictions on business activities and closure of premises. We have regulation 6, which is the restriction on freedom of movement. That's the one that's had a lot of attention. And also we have regulation 7, that imposes a restriction in relation to gatherings of more than 2 people in a public place. So if we start with businesses, Emma, what's been prohibited in relation to businesses?
Well, regulations 4 and 5 distinguish between 5 different kinds of businesses. First, for all businesses listed in Part 1 of Schedule 2, they must stop selling food or drink for consumption on premises. This includes restaurants, cafes, bars, pubs.
Emma, does that mean they have to close completely?
No, they can remain open, but only for consumption off premises, so only for takeaways and deliveries. The second category, which is much broader, comprises those listed in Part 2 of Schedule 2.
Emma, that list in Part 2 of Schedule 2, I was having a look at that just before we logged on. As far as I understand it, that seems to be a list of non-essential businesses that require a lot of people to be in close contact with each other.
That's right. There are 19 businesses listed in Part 2 of Schedule 2, including cinemas, theatres, nightclubs, casinos, spas, massage parlours, auction houses and fun fairs. And all of these must be closed for the duration of the emergency period, so potentially up to 6 months, but reviewed every 3 weeks.
I understand there's an exception in relation to some of those.
Yes, in Regulation 4.5. So cinemas, theatres, concert halls, museums, galleries, and even bingo halls can continue to operate, but only by broadcasting performances to people outside their premises.
What does that mean? That means people remote viewing theatre performances?
So think live streaming on the internet, pre-recorded performances that you can access through links by email or on the internet. Those are the most obvious ways that will happen.
Yeah.
And the third category is holiday accommodation, which is very widely defined and includes not just hotels and B&Bs, but also caravan parks, campsites and holiday properties. These must also close for the duration of the emergency period, but again, there are exceptions in Regulation 5.4.
Emma, just looking at those exceptions in Regulation 5.4, so holiday accommodation can only stay open if it's for people who can't return home, for people who are homeless, people moving home, or people that need to attend a funeral or using the accommodation as their main residence. And I think they can also be used for hosting blood donation sessions or indeed anything that has any purposes requested by the health secretary or a local authority.
Yes, and that could be, for example, if the health secretary wanted to use a hotel to house key workers.
So we saw that, I think earlier this week, I think Chelsea Football Club, or the people that own Chelsea Football Club, made one of their hotels available to NHS staff.
Yes, absolutely. And the fourth category comprises places of worship, community centres, crematoria and burial grounds. Specific rules apply to each of these in Regulations 5.5 to 5.8. Starting with places of worship, these must be closed except for funerals, to broadcast acts of worship, or to provide essential voluntary services or urgent support services, which includes food banks or support for the homeless or vulnerable people, and blood donation sessions, as you've already referred to, Remi. The position is similar for community centres. These can only remain open for essential voluntary activities or urgent support services. And finally, crematoria and burial grounds must remain closed to the public except for funerals and burials.
And so now that takes us to the fifth and final category of businesses, which is quite rather ominously called simply other businesses.
Yes, it's quite a broad category, defined in Regulation 5.1 as a business offering goods for sale or hire in a shop or providing library services. These must close, except that they can continue to trade remotely by making deliveries or taking orders through a website, by post, telephone, text message, and presumably any other method of communication that doesn't require someone to visit the shop. But there is a list of 19 essential businesses in Part 3 of Schedule 2 which are exempt from this restriction. This includes businesses selling food, pharmacies, newsagents, off licenses, petrol stations.
Emma, are we, sorry Remi, are we able to distinguish, or do the regulations distinguish between businesses selling food, which obviously fall within the exemption, and restaurants which must close?
Well, there may be some businesses that fall into more than one category, and the result is likely to be the same. So where you've got a Whole Foods that has a cafe serving food, you will still be able to buy food from the supermarket at part of the premises, but you would only be able to take away from the cafe part of it. So you may find that there are businesses that fall into more than one category, but it's unlikely in reality to cause much of a difficulty because the effect is likely to be the same.
Yeah.
And Emma, I couldn't help but notice that one of the essential businesses in that list in Schedule 2 is bicycle shops. And I think there must be someone in government that's particularly keen on bicycles, because I think when the list was first circulated, bicycle shops were listed there twice.
That's brilliant. So these 19 essential businesses are exempt from the general restrictions in Regulation 5.1, and they can all remain open and serve customers on their premises. Jennifer, is the position for other businesses the same in Wales, Scotland and Northern Ireland?
Yes, broadly speaking, it's the same. In relation to that last category of businesses that you just mentioned, the essential businesses, Part 3 of Schedule 2, these remain open, but in Wales and Scotland, these businesses have an additional requirement whereby they have to take all reasonable measures to preserve social distancing. Mm-hmm. So this might include limiting the number of people who enter the premises. The idea being that you preserve a 2-metre distance between people on the premises and people waiting outside the premises. This 2-metre rule doesn't apply to members of the same household though, or to carers. Another difference would be the use of prohibition notices. So in England, Wales and Northern Ireland, you can only issue a prohibition notice in relation to these restrictions on business activities that you've just been talking about. Mm-hmm. In Scotland, however, a prohibition notice, it can be issued in relation to any of the other restrictions as well, the ones that you're about to go on to talk about.
Thanks very much, Jennifer. That now takes us to the next category of restriction, which is in Regulation 6, and that's the restriction on freedom of movement.
Understandably, this is the one that's received the most media attention. Yes,
that's right. And if we look at what that regulation actually says, it is remarkably straightforward in the way that it's drafted, or it appears straightforward, in that Regulation 6, paragraph 1, it is one sentence, and it simply says, and I'm quoting, during the emergency period, no person may leave the place where they are living without reasonable excuse. Now, I think we can probably break that sentence down into 3 parts. So the first 2 are relatively straightforward. That prohibition only applies during the emergency period. So initially, that will be for 3 weeks. That will be reviewed very shortly. The government are currently reviewing the position. And there's a maximum backstop of 6 months. The second element is these words, the place where they are living. So effectively, your home. Those words are broadly defined. So Regulation 6, subparagraph 3, says that the place where you are living includes a garden, it includes passages, it includes outhouses, and it also includes other appurtenance of such premises. And you can tell I struggle to say that word, let alone give you a precise legal definition.
It means something attached to a larger property.
Okay, well that's very helpful. But the third element of of Regulation 6, paragraph 1, is this need for a reasonable excuse to leave your home.
And Remi, isn't that really what makes Regulation 6 so extraordinary? Because it is now a criminal offence to leave your home without a reasonable excuse to do so.
And in terms of working out what qualifies as a reasonable excuse, Regulation 6.2 gives a non-exhaustive list of 13 examples. And it's important to stress that these are just examples. If you have the regulations open, it may help to have the full list in Regulation 6.2 up on your screen. Those examples include the need to seek medical assistance, the need to obtain basic necessities for those in the same household, including pets, or for vulnerable persons.
And that term, Emma, vulnerable persons, there's a list in Schedule 1 of the regulations which define that term, so vulnerable person. And what's interesting about that list is that list sets out a number of medical conditions, particularly chronic medical conditions that would affect people that have coronavirus. But interestingly, it doesn't include persons over the age of 70. So someone who's aged over 70 doesn't fall within the definition of a vulnerable person within the regulations.
That's right. Other examples of reasonable excuses are to travel for work purposes, if not reasonably possible for the person to work from home, and to take exercise, either alone or with other members of the household.
And Emma, in relation to exercise, I've seen that term, again, it's not defined in the regulations. The regulations don't tell us, well, certainly the English regulations don't tell us how many times a day you can exercise or how far from your home you can travel to exercise.
That's right. And although when these measures were announced, there were some references to only one form of exercise a day.
Well, Emma, can I just cut in, because it wasn't just when these were announced, because yesterday I received my leaflet. I received my letter from number 10 Downing Street and my coronavirus leaflet, which I noticed on the first page set out the only circumstances in which I can leave the house. Those are shopping for basic necessities, one form of exercise a day, any medical need, and travelling for work purposes, but only where you can't work from home. But it seems that what you're saying is that that isn't actually the state of the law.
It's important to recognise that some of the guidance goes beyond what is actually provided for in the regulations, and it will be a matter for those enforcing the regulations to decide on a case-by-case basis what constitutes a reasonable excuse to leave home.
So the legal test is simply whether you have a reasonable excuse or not.
Charlotte, I'm not sure I would say that it's simply a reasonable excuse, because if you look at Regulation 6 as a whole, I think there appears also to be a necessity requirement. So going back to that first paragraph of Regulation 6, that sentence that I read out, it's clear that you must have a reasonable excuse. And then we have that non-exhaustive list of examples in the second paragraph that Emma started to set out. But the first sentence of the second paragraph goes on to say that for the purposes of paragraph 1, a reasonable excuse includes the need to, and then it goes on to list the 13 examples. So looking at those words, the need to, I think it's arguable that those words import a necessity requirement. So what that means basically is that something can only be a reasonable excuse if there's actually a need to do that thing. But no doubt, I mean, this is going to be really a very difficult prohibition for the police to deal with, because a reasonable excuse for one person may not be a reasonable excuse for another.
Yeah, and also some of the examples of reasonable excuses in Regulation 6.2 are pretty broad, aren't they? For example, you've got the example at M, which is the need to avoid injury or illness or to escape a risk of harm. And injury and harm are not defined. So the regulations don't specify, for example, if a need to avoid suffering psychological harm could be a reasonable excuse.
And Charlotte, it's worth highlighting that there has been some guidance from the College of Policing recommending that officers bear in mind whether or not it is safe for someone to be at home and whether there may be safeguarding issues.
Yeah, and there have also been reports, haven't there, unfortunately, that domestic violence is more prevalent in the current circumstances. And perhaps that example at M appears to be geared to some extent to deal with the risk of domestic violence.
I think there's another aspect of Regulation 6 that's quite interesting, and it's been pointed out already by some commentators, and it's that the way that it's been drafted means that it appears that it's only a prohibition to leave your house without a reasonable excuse.
Yes, I noticed that. So the regulation is drafted, no person may leave the place where they are living without reasonable excuse, and not no person may be outside the place where they live without reasonable excuse.
Yes, and I think that to me seems to be a pretty significant difference, because I think one of the things that officers are going to need to grapple with is circumstances where maybe someone has left their home for a very good reason, something that amounts to a reasonable excuse, whether it's exercise or buying groceries for a vulnerable family member. But what if that person then goes on to do something that isn't a reasonable excuse?
Yes, I think in those circumstances, the enforcement regulation, Regulation 8, may give the power to direct a person to return home or a power to remove the person. But I'm going to talk about that a bit more when we get on to enforcement powers.
And Jennifer, you've been looking at these regulations insofar as they might be applicable in Scotland, Wales and Northern Ireland. Are there differences there in relation to freedom of movement?
There are. For the most part, again, there's very significant overlap. Probably the most interesting difference, and one that has received some attention so far. So you mentioned already that in England, there's no restriction on the number of times you can leave your home to exercise. This isn't the case in Wales. So under the Welsh regulations, you cannot exercise, or you cannot take exercise more than once per day.
So in England, or rather in Wales, it's not a reasonable excuse to exercise more than once a day, but it is in England.
Yeah, apparently so.
Okay, well that's interesting.
Well, that takes us to the third category of restriction, Regulation 7, which prohibits any person from participating in a gathering in a public place of more than 2 people. There are just a handful of exceptions here, where all people in the gathering are members of the same household, where the gathering is essential for work purposes, where it is reasonably necessary to facilitate a house move, provide care or assistance to a vulnerable person, to provide emergency assistance, or to participate in legal proceedings or fulfill a legal obligation. And finally, to attend a funeral.
Emma, isn't there some restriction on attendance at funerals in Regulation 6 as well?
Yes, so you may not be breaching Regulation 7 by attending a funeral, even if it was the funeral of someone you've never met. But you will fall foul of Regulation 6G by leaving the house to attend a funeral unless you are a member of the deceased's household, a close family member of the deceased, or, if nobody falling within these 2 descriptions is attending, a friend of the deceased.
And Emma, the prohibition on gatherings, so it's drafted in the way that it says it's a prohibition on gatherings of more than 2 people. But doesn't that leave a gap in that someone could leave their house and meet another person from another household? There'd be a gathering of 2 people in a public place, but they wouldn't be breaching Regulation 7.
Well, again, it could go back to the question of a reasonable excuse under Regulation 6. Someone who leaves their home to meet someone from a different household needs a reasonable excuse to do so, leaving home to catch up with a friend is probably not going to cut it. And Jennifer, looking at the other regulations, is this prohibition the same in all 4 nations?
It's broadly similar, for sure. There is one interesting addition in this area in the Welsh regulations. So in those regulations, there is a requirement to close public paths or land based on these places being liable to have large numbers of people congregate there, or where their use otherwise poses a risk of spreading infection. So this might include, for example, closing busy paths in a national park, or it might include closing National Trust land, for example. So this isn't part of the gathering restrictions per se, but is clearly motivated by a similar kind of concern about the danger in the current circumstances of having groups of people in close proximity to each other.
Okay, well, I think we've probably covered the restrictions, or the principal restrictions, in relation to each of the 3 activities. Now let's turn to powers of enforcement, and these are found in regulations 8 through to 10. And the first point to make is that enforcement powers extend to all relevant persons. And relevant persons is a term defined in Regulation 8:12 as being a police constable, a PCSO, so Police Community Support Officer, a person designated by the Health Secretary, and a person designated by a local authority. But that last category, persons designated by a local authority, is only in relation to restrictions on business activities. Local authorities can't designate people to enforce the restrictions on movement or on gatherings. Now, enforcement powers differ across the various restrictions. So starting with the restrictions on businesses, business activities, what a relevant person is empowered to do in respect of those restrictions is to take such action as is necessary to enforce any requirement, and they may give a prohibition notice to a person if it is reasonably believed that the person is contravening a requirement and it is necessary and proportionate to do so. As to the prohibition on freedom of movement, there are a number of enforcement powers here, but for each of these there's a general rule, and that is that the relevant person enforcing them must consider that it is a necessary and proportionate means of ensuring compliance with the requirements. And as long as that rule is met, then there are a number of things that the relevant person may do. First, they may direct or give a reasonable instruction to someone to return home, or they may remove them to their home using reasonable force if necessary. If the person outside the home, without a reasonable excuse, is a child accompanied by an individual who has responsibility for that child, then that power to direct or instruct someone to return home may be used against that individual. And that individual must, so far as reasonably practicable, ensure that the child complies with the direction given by the relevant person. If there are reasonable grounds to believe that a child is repeatedly failing to comply with Regulation 6, then the relevant person can direct an individual with responsibility for the child to secure, as far as reasonably practicable, that the child complies with that restriction. And finally, in relation to restrictions on gatherings, the enforcement powers here are as follows. The relevant person may take such action as is necessary to enforce any requirement. This includes, providing it is necessary and proportionate to do so, directing or giving a reasonable instruction for people to disperse and return home, or to remove people to their home using reasonable force if necessary. And that same rule in relation to children that I talked about a moment ago also applies to gatherings. Now, enforcing these restrictions is obviously going to be challenging. Officers will need to pay close attention to the wording of the regulations, but they'll also need to strike the right balance between securing compliance, but also avoiding disorder and unrest at a time when public services are already very stretched. And of course, officers must keep in mind at all times that ultimately these are public health measures, and any enforcement action that they take should be taken with a view to securing and protecting public health.
Charlotte, what about powers of entry?
Well, there's no power of entry under the English regulations. There is a power, as I think I've just outlined, to take such action as necessary to enforce the restrictions on business activities and gatherings. But it's not clear from the regulations if that encompasses a power of entry. It is different with the Welsh regulations, I understand. Jennifer, can you help with that?
Yes, so under Regulation 11 of the Welsh regulations, there is an express power of entry, using reasonable force if necessary. So this power is available where a relevant person has reasonable grounds for suspecting that a regulation is being, has been, or is about to be contravened on the premises, and further that they think that it's necessary to enter the premises in order to ascertain whether that is indeed the case. So it's potentially quite an interesting difference there for sure.
Yes, indeed. And of course, all of the usual police powers remain at the disposal of officers in appropriate circumstances, and those, of course, include powers of entry under PACE. But speaking of PACE,
well, Charlotte,
under Regulation 9, sorry, Emma.
I was just going to ask whether breach is in fact a criminal offence. Breach
is a criminal offence in respect of any of the restrictions, so businesses, movement and gatherings. If you don't comply with those restrictions, you are committing a criminal offence. That's provided for by Regulation 9. And it's also an offence to obstruct without reasonable excuse any person carrying out a function under the regulations, or to contravene a direction given under Regulation 8, or to fail to comply with a reasonable instruction or a prohibition notice given by a relevant person under Regulation 8.
And in terms of penalties?
These are all offences which are punishable on summary conviction by a fine, and there's no limit expressed in terms of the amount of that fine in the regulations.
And isn't there also the possibility to give a fixed penalty notice?
Yes, so under Regulation 10, an authorised person may issue a fixed penalty notice, and the definition of authorised person is the same as a relevant person for the purposes of enforcement, so constables, PCSOs, persons designated by the Health Secretary, and in some circumstances, persons designated by the local authority.
I noticed you put a lot of emphasis on the word may there.
Yes, that is the word used in Regulation 10.1, and that is indicative that there is some discretion as regards the FPNs. So it will be a matter for those enforcing the regulations to decide whether to issue a fixed penalty notice or whether to invite the CPS to proceed with prosecution under Regulation 11 or neither. But the regulations don't tell us how that discretion should be exercised. And if a fixed penalty notice is issued, then no criminal proceedings can be commenced for 28 days, and payment of the fixed penalty discharges liability for the offence. So there can't then be a prosecution if you've satisfied the FPN. And
what about the amount of the fixed penalty?
So for a first offence, it's £60. That reduces to £30 if it's paid within 14 days. And it then doubles for each offence, but that's up to an absolute maximum of £960. So I think that covers really the main elements of the regulations. I know that you've been following on avidly, and I can see the chat popping up in the corner of my screen. This would be a point to deal with some questions if we can, Remi. I think you've been most closely monitoring the chat.
I have. So I think we have 3 questions really that have come up. One was actually asked before today's session, and that is a question just sort of as a general matter, how one might deal with the situation of house parties.
Remi, shall I take that one?
Sure.
Well, attending a house party would not of itself fall foul of the restriction on gatherings in Regulation 7, because Regulation 7 only applies to gatherings in a public place. But attendees who don't live where the house party is being held will very likely be in breach of Regulation 6. Attending a house party is unlikely to be deemed a reasonable excuse for leaving home. There is obviously nothing in the regs that prohibits people who live together having a party in their own home, though. So it's important to be careful about that. So if you've got a flat share situation with 10 people living together, then they're perfectly entitled to have a house party under the regulations, at least.
That's really helpful. We've got the second question, which is a very tricky one. And I open this up to all 3 of you. And it is this: what about someone who might be a traveller? So how do we fit that person into the current regulations in relation to the prohibition on movement? Now, while Charlotte was dealing with enforcement, I went back to Regulation 6 to look very carefully at what that says. And I think, in effect, it would fall between one of 2 things. So Regulation 6, paragraph 3, gives us that definition of a place where someone is living. And that says it includes premises where they live, together with lots of other things, including gardens and yards and stairs and garages. So I think the first thing is that that doesn't seem to be an exhaustive definition because of the use of the word it includes. But it is a very broad definition. So the first question really would be, potentially, could that person fall within the definition in 6.3, which is that is somewhere where they're living and therefore it is their home and they need a reasonable excuse to leave that place. The second potentially relevant one is paragraph 4 of Regulation 6, which states very clearly that that doesn't apply to anyone that is homeless. So someone who is homeless that doesn't have somewhere to go, they're obviously not going to be prohibited from leaving their home because they don't have one. So I think that's probably, it's not a very neat answer, but I think we would be looking at one of those 2 provisions to answer that question.
Yes, I mean, it seems to me that travellers would be caught within Regulation 6 by virtue of subsection 3. As you say, it is the only exception is one which is expressly set out, which is if you're homeless. There's no basis for saying that someone who is a traveller is homeless, seems to me. And therefore, I think they would fall within the definition of someone to whom Regulation 6 applies. The difficulty, I suppose, is about them moving around, the fact that their home is temporary and can be moved at any time. That's tricky. But equally, I suppose we may come back to the point that we were talking about earlier about how the regulation is drafted, that you may not leave your home. You may not be outside. So in some senses, that might assist.
Yeah, but I agree with you, Charlotte. That's a really tricky question because regulations they tell us you can't leave home, but they don't tell us if you're able to move your home, are you allowed to do so? Yeah. So that's potentially very difficult. And I think the answer is, I'm afraid, we simply can't say in the abstract how a court dealing with this might interpret those regulations. Yeah. The third and final question we've had is a very technical one, which goes to effectively the enforcement of these regulations and what happens where you have district and county level authorities. And the person that's asked this question has been looking at the Act, the 1984 Act under which the regulations are made, and looking at the definition of a local authority in the Act. And I think in answer to that question, quite simply, is that actually what we need to do is, for enforcement of the regulations, we need to look specifically at the regulations and not at the Act. So the regulations say that they can be enforced by a police officer, a PCSO, someone designated by the health secretary, but also someone designated by a local authority. Now, importantly, and I think that's already been pointed out, that for local authority enforcement, firstly, that's only for restrictions relating to businesses. So local authorities can't get involved in enforcement for freedom of movement or for gatherings. But in answer to that question, that there would be nothing to stop a local authority designating anyone that it sees fit. So be that someone that works specifically for the local authority, or a contractor, or someone that's involved with the local authority in some other way. There's nothing in the regulation that actually says who the local authority can and can't designate for enforcement purposes. So I hope that's answered all the questions that we've had.
Thanks, Remi. Well, there are other matters of detail, of course, in the regulations that I'm afraid time doesn't permit today for us to cover all of those. Some of those are set out in our guide for police forces in England, which is available on our website, as I said earlier. And we've also posted a link to that guide in the chat for this webinar. And as I mentioned, we will soon release the guide for police forces in Wales. But I think that's all, folks, for today. And thank you very much for tuning in.
Thank you.
Thank you.